Well, as Catherine Herridge noted earlier, U.S. officials reportedly say the surviving suspect told the FBI about the bombings during 16 hours of questioning before he was advised of his constitutional rights to remain silent and then he could have an attorney. Then those officials say a judge arrived at the suspect's hotel room with a representative from the United States Attorney's Office, the hospital room, I don't know what I said there, but I meant hospital room, and advised the suspect of his rights. Then he stopped talking. That's the story. Let's take this to the judge. Fox News chief judicial analyst, Judge Andrew Napolitano. First of all, I want to get the facts out of the way here because I think they're important. The reading of the rights does not activate them. The absence of the reading does not remove them. They simply are. They are rights. And he, like you and I, has the right to remain silent. What's confusing about this?
Nothing. Nothing. The way you said it could not have been said more accurately.
Those are just the facts.
Or more eloquently. So here's what happened. He is being interrogated in a hospital room by, we don't know how many, FBI agents and probably some intelligence agents. The time is ticking. He's been in custody 72 hours. The law says you have to keep, in order to keep him, you got to file a criminal complaint with a federal judge to justify keeping him beyond that time period.
Otherwise, it's
kidnapping. If you don't file the complaint, then you have no right to hold the body, no matter what you say the evidence is. So at the same time the interrogation is going on, another team of FBI agents, very prudently in downtown Boston, are reviewing the evidence and preparing an affidavit for a federal judge. Here's the evidence. Here's the evidence we would introduce in court. Here's the crime we believe he committed. We're going to file a charge against him for using a weapon of mass destruction, for committing murder, and for destroying property, and for maiming people. And that's filed. Once that's filed, that starts another clock ticking. And that clock is under the federal rules of criminal procedure. When you file a complaint against someone, if they're out there, you go arrest them, you bring them before a judge. If they're already in your custody, you bring them before a judge. If you can't get them before a judge because of their physical condition, you get the judge to them. This is not rocket science, Shep. This is criminal procedure 101. It happens in every courthouse, state, local, and federal, every day in the United States of America.
What is the ruckus? It's as if people think because they didn't read him his rights, he did not have them. He had them.
Correct.
What they're suggesting is that we shouldn't have told him what his rights are.
Ah, that's where they are wrong, because the Supreme Court recognized in the Miranda case, most people don't know they have the right to remain silent, especially in the face of a half-dozen government agents shouting at you and demanding that you answer. In order to correct that most people don't know, the Supreme Court directed that whenever anyone is in the custody of the government, any American government, local, state, or federal, the custodian of the human being must tell that human being, I'm going to ask you questions and I want you to answer, but you have the right to remain silent. You don't have to answer. When a defendant, and he turns from suspect to defendant at the moment the criminal complaint is filed, when a defendant is brought before a judge for the first appearance, whether it's in a hospital room or a courtroom, as is traditionally the case, the first order of business for the judge to make sure that person did receive the Miranda rights. So the judge re-gives the Miranda warnings, even if they had already been given. There is nothing new about this. There's nothing remarkable about this. Now, I need to address this so-called public safety exception. The public safety exception to the Miranda warning does not last for 48 hours. That seems to have come from somewhere in the Justice Department and perhaps somewhere in the media. I don't know.
That someone says it, just says it, that it comes out of someone's mouth does not make it true.
Correct. The public safety exception exists for a very short duration during the process of the arrest. You arrest someone and they have a holster without a gun. And so you say to them, where's the gun? You can ask that. The police can ask that to preserve them, to protect themselves and others at the scene of the arrest without giving the Miranda warnings. But once that person is secured in police custody and doesn't have a weapon in his hands, the obligation to administer the Miranda warning arises immediately. Not 48 hours later, but immediately. That's the law everywhere in the United States.
I'm out of time and have been for a while, but I wonder how concerned you are that when these big and troubling events happen that bring us together as a nation and we mourn in unison, that we will go to the extremes of the Constitution and sometimes beyond it.
I am profoundly concerned that when the evidence of guilt is overwhelming and the people are weeping because they have been deeply disturbed and hurt and harmed and maimed and killed, the government will find ways to go around the Constitution. And when the government has done that historically, it has never worked. It has never brought about safety. It has only lessened freedom.
The conservative columnist George Will with a fascinating column in the Washington Post this morning. It's at WashingtonPost.com, and I think worth a read.
It's a great story about a similar event in World War II and how it backfired on the government.
Good to see you, Judge.
Thank you, Shep.
You have the rights, you know.
Yes, thank you.
I'm not going to read them, but
Man, you stated it perfectly.
you already have them.